Stephen Gill was registered with the Health and Care Professions Council as a paramedic and worked as a nurse employed by Worcestershire Acute Hospitals NHS Trust. On the 30th of August 2017, Gill was arrested on the suspicion of possessing indecent images of children, to which he pleaded not guilty. On the 10th of December 2018, the registrant was convicted of 3 counts of producing indecent photographic material or pseudo-photographs of children, and 1 count of distributing such material. This breaches many Queensland laws, including the Ambulance Service Act 1991, in which a designated officer is only authorised to disclose information that is required or permitted. It also breaches the privacy and protection of children discussed in the Human Rights Act 2019. It refers to people having the right to not have their privacy, family, home, or correspondence unlawfully attacked, as well as every child having the right, without discrimination, to be protected in accordance with their best interests. As a paramedic, Officer Mr. Gill had a duty to uphold these laws and serve to protect children, not to abuse them. Based on the nature of the offences concerned, the registrant's fitness to practice was deemed impaired, and Mr. Stephen Gill was consequently struck off from the register. The panel took into consideration a significant number of images, 910 total in Gill's possession, and his actions to conceal this behaviour over a 2-year period. Of these images, 98 were Category A, the most serious level, 74 at Category B, and the remaining 738 at Category C. One specific aggravating factor within the distributing offence was the fact that a child within the Category A images involved a 2-year-old. Consequently, it was submitted to the panel that the registrant had breached Standard 9 of the HCPC Standard of Conduct, Performance and Ethics, and that his actions fell below the expectation of a registered healthcare professional. Additionally, the finding of impairment was to be made in the public's best interest to prevent undermining the confidence in the paramedic profession. The Birmingham Crown Court sentenced Gill to 18 months imprisonment, subjected him to 5 years of a sexual harm prevention order, and placed him on the sex offender register for 10 years. The Child Protection Act 1999 is a Queensland law applicable to the allegations against the registrant. Subsection 9 defines harm to a child as any detrimental effect of a significant nature on the child's physical, psychological, or emotional well-being. Gill's allegations correspond directly with this legislation, as the defendant caused harm through exploitation of children through explicit photography, evidenced through Section 9, subsection 3b. The images of which Gill had in his possession are identified as child exploitation material, which under Chapter 22, Section 207A of the Criminal Code, Child Pornography and Abuse, Amendment Act 2005, states that this material depicts someone who is, or apparently is, a child under 16, in a sexual context including, for example, engaging in a sexual activity or in an offensive or demeaning context, or being subjected to abuse, cruelty, or torture. Material includes anything that contains data from which text, images, or sound can be generated. It had been proven that Mr. Gill distributed child exploitation material involving a 2-year-old and additionally transmitted and made available the aforementioned child exploitation material to a particular person. If this case occurred in Queensland, through Mr. Gill's actions, he would be prosecuted under the Criminal Code, Chapter 22, Section 228C, 2, A to D, and a maximum penalty of 10 years of imprisonment would have been implemented. In Queensland, persons found to make and distribute child exploitation material see jail time, as seen in R v GAE 2008. The respondent was sentenced to 2 years imprisonment for these acts. Mr. Gill would also face an additional penalty of up to 5 years imprisonment due to knowingly possessing 910 indecent images of children. An example of this occurring in Queensland is the case of R v Edwards 2019, where a federal police officer used a carriage service to access child pornographic material. 639 images, 2 videos, and highly explicit stories were obtained. He was later sentenced to 15 months imprisonment. Comparing the two cases, it is highly likely Mr. Gill, like Mr. Edwards, would receive prison time for the possession of similar child exploitation material. If Mr. Gill was to work in Queensland, he would also be seen as civilly liable as he performed a breach of duty when participating in child abuse through the possession and distribution of child exploitation. As a result, implications to registration would occur. The first domain of the professional capabilities for registered paramedics states that paramedics must practice ethically and professionally, be consistent with relevant legislation and regulatory requirements. Due to civil and criminal prosecution, Mr. Gill would not have been able to be registered as a paramedic due to not withholding the principles of fitness to practice and reporting obligations under the first domain are not met. The Queensland law provides protective measures to ensure patient safety for our community, in particular the vulnerable, such as children. Stephen Gill is no longer fit to practice as he has breached consecutive laws posing future risk to patient safety. Furthermore, the numerous children and families that trusted Gill's professional-patient relationship were wrongfully treated as he exploited personal information via messages disregarding confidentiality and his duty of care.